Bank of America is submitted on the briefs. Also, Higadera Segura is also submitted on the briefs. And that takes us to Ma versus Sessions.
Good morning, Your Honors. I represent Mr. Ma, and well, his last name is Ma. I represent Mr. Ma, and
your name?
My name is Jean Wang. The issue before this court is a very specific issue, which is whether 8 CFR 274A12B, this particular regulation's grant of authority to continue employment, includes lawful immigration status. This is a very important issue for all of the people that come under this statute, which is all the work-based visa non-citizens. I didn't draft the briefs, but so I'd like to add some points that aren't mentioned in the briefs.
Well, you're supposed to include all your arguments in your briefs.
Yes. They're mentioned, but not elaborated on as I would had I drafted it. But so I'd like to address it. The government tries to expand this case beyond what this case is by saying that all employment authorization would mean status for everyone, which is not this case. The issue here is this specific statute, which is very specific to work-based visa non-citizens.
So the argument I found most persuasive of the government's is that another regulation, 8 CFR 1245.1, defines lawful immigration status as exclusively limited to 6 categories, which doesn't include work authorization under 274A.12B20. And so therefore, at least one of their theories is, so long as the regulation is valid and it's been upheld by other circuits, that would exclude your argument.
That's not true. Because if you look at the statute, the definition of lawful immigration status, under subsection 2 of that statute, it says, an alien admitted to the U.S. in non-immigrant status as defined in section 101A15 of the Act, whose initial period of admission has not expired, or whose non-immigrant status has been extended in accordance with Part 214 of 8 CFR Chapter I. And according to that chapter, specifically 8 CFR 214.1 subsection E, it states a non-immigrant in the U.S. that has authorized employment. So it specifically refers to those that are authorized for employment.
Now, you've sort of lost me there a little bit. Let's go back and answer. When you said the statute, which provision are you talking about? Are you talking about 8 USC, or are you talking about the regulations?
No, I'm talking about the definition. Well, I was addressing Your Honor's reference to that, to the definition of lawful immigration status.
That's in 8 CFR 1245.1?
Right, subsection 2.
Little
I.
to an alien admitted to the United States?
Yes, double I.
Okay.
Right, it refers to Part 214 of 8 CFR Chapter I. Do you see that there?
Yes.
Okay, and so that specific, that chapter is large. So within that chapter is 8 CFR subsection, 8 CFR 214.1E, which specifically talks about employment.
And so, so I'm looking now at 8 CFR 1245.1D 1, little 2I, and yours, and may include whose initial period of admission has not expired or whose non-immigrant status has been extended in accordance with basically 8 CFR Part 214. And you're saying that that includes 274A 12B20, or what are you saying? Help me with that.
Yes, I'm saying that includes 8 CFR 214.1E.
And
Which-
so how does that help you?
Which provides for employment.
Right,
So,
but does it also, does it cover what your client got, which is work authorization, the automatic work authorization under 274A.12E20?
yes, because it specifically deals with work authorization for those with extended visa applications.
Okay, but that particular section has to do with an automatic extension. So is that
The
specifically
extension
referenced?
is not necessarily automatic. It has to be a timely file.
It doesn't just, my question is that reference in 8 CFR Part 214.1E?
Right, that reference is to employment. And
Well, I'm sure there's a lot about employment, but the specific provision that your client is relying on is 274A.12B20. So my question to you is, what's the connection between 8 CFR Part 214 and that section you're relying on?
the connection is that the employment, the definition of lawful immigration status that you had started off with, right, refers to meaning anyone, this type of person can have lawful immigration status, which is double I, someone that has an extended visa. So as defined by 8 CFR Part 214. So you go to 8 CFR Part 214, and this 214.1E specifically deals with those with employment, and specifically states any other non-immigrant in the U.S. may not engage in any employment unless he has been accorded a non-immigrant classification, which authorizes employment. And so the subject regulation here provides for that authorized employment for someone that has specifically an extended visa application pending. And so that is the link between these two. The link between the lawful immigration status on one side, and then this subject regulation, the link is 8 CFR 214.1E.
Do you have a case by a court in line with your provision, or are you just saying this is common sense and our own interpretation?
No, Your Honor, what you're deciding today is precedential.
Okay. No case of any kind of court?
Well, the key case that petitioner, Mr. Ma, relies on is the El Bodari case. I'm probably pronouncing it wrong.
So let me ask you a question. You started off by saying you wanted to add some argument, or you wanted to refine the argument in the brief. You know, the case was confusing to me when I read the brief. You know, and I read your brief twice.
I'm not the
I
writer.
I read the appellant's brief twice because it's confusing. You know, we don't deal with this stuff every day,
Yes, Your Honor.
and it doesn't come sort of like au naturel. You know, you got to work with it, right?
Right.
And when I look at your brief, I don't even see CFR 8 CFR 214.
I apologize, Your Honor. I'm not the drafter of the brief.
This isn't even,
I was substituted in.
I didn't.
I agree.
I really, your arguments need to be in the brief, because then I wasted my whole entire time.
Yeah. I completely agree with you, and I apologize for my predecessor's brief that it's not more.
Well, I'm not so sure your predecessor's brief was not, thorough and complete and a good brief.
So I want to make it up here in oral argument and explain. And I can submit another 28J afterwards if.
That's not how 28Js work.
Right, before, yes.
If your client loses here, does he have any other recourse?
No, he already has a deportation order. He already has a removal order. My client is a highly talented,
No question about that.
high-skilled data scientist. I didn't even know they existed. And he exists. And he had a lot of options available to him. He could have applied for asylum. His parents are political dissidents from China that have been granted asylum, both of them. And he could have continued his studies at San Diego State University. He had an offer to go to graduate school there. So he has an MBA, he has a BA, he has 8+ years of experience in the field. He had a lot of options for him. If I represented him earlier, I would have done more, but he's not one of the people that the president wants to remove. He is far from that type of person. There's a technicality here, and we're talking about a difference of 6 days. I mean, why this issue is important is because he filed his adjustment, his employer filed an adjustment of status application for him to get a green card. But that was filed beyond 180 days. He's allowed 180 days of unlawful presence. So it was filed beyond 180 days. And the key, whether or not it's beyond or under, we're saying it's 174 days. So the difference, whether it's past 180 or actually 174 days, is based on this statute. Whether or not this statute gave him lawful immigration status. And so that's the crux of why we're arguing this statute. And so we're just arguing for that 6 days. So we were talking about calculations in the prior case. We're just arguing for 6 days. And it comes down to this statute. This statute is, if he was authorized to work and if he was allowed to be in the United States during that period, then he would have 174 days only of unlawful presence, and thus he would be able to adjust status. And so USCIS had denied his employment adjustment of status because of this calculation. That's why.
You want to save some time for rebuttal?
Yes, I do.
Okay. Let's hear from the government.
Thank you, Your Honors.
May it please the Court, Robert Tennyson for the government. It's one of those basic fundamental properties of an immigration law system that's based upon the government granting benefits to come into the country and stay in the country for non-nationals, that an individual can't grant themselves status. And yet that's what the petitioner here is asking us to do. He's saying, merely because I